Hello friends, I hope you are doing well. I am Dr. Gurmanpreet Kaur, Associate Professor of Law at Rajiv Gandhi National University of Law, Punjab. Today we will discuss the topic of dissolution of marriage under Muslim law, part 1. So let's start with an introduction. Under Muslim law, marriage is a religious duty as well as a contract. It is a civil contract because one party makes an offer of marriage and the other party may or may not accept the offer. The consideration is the dower which the husband is required to pay to his wife. After marriage, a woman does not lose her individuality. She remains a distinct member of the community. Her existence as a personality does not emerge from that of her husband. The contract of marriage gives no power to anyone over her personal property beyond what the law defines. A woman remains the absolute owner of individual rights even after marriage. She can alienate or transfer the property in any way she chooses without any extraneous control over her husband. Further, let's discuss the nature of Muslim marriage briefly. There are divergences of opinion with regard to the nature of Muslim marriage. Some jurists are of the opinion that Muslim marriage is purely a civil contract, while others say that it is a religious sacrament in nature. In order to better appreciate the nature of Muslim marriage, it would be appropriate to consider its different notions. For instance, first, as marriage requires a proposal, that is ijab, from one party and acceptance, that is kabul, from the other. So does the contract. Moreover, there can be no Muslim marriage without free consent, and such consent should not be obtained by means of coercion, fraud, or undue influence. Secondly, just as in case of a contract entered into by a guardian on attaining majority, so can a Muslim marriage contract be set aside by a minor on attaining the age of puberty. Thirdly, the parties to a Muslim marriage may enter into any antenuptial or postnuptial agreement that is enforceable by law, provided it is reasonable and not opposed to the policy of Islam. The same is the case with the contract. Fourthly, the terms of marriage contract may also be altered within legal limits to suit individual cases. Fifthly, although discouraged by the Holy Quran, like any other contract, there is also a provision for the dissolution of marriage contract. In a landmark case decided almost more than a century ago, Justice Mahmood emphasized the contractual aspect of Muslim marriage in the case of Abdul Qadir versus Salima, 1886, ILR 8, Allahabad 149. Describing the nature of Muslim marriage, Justice Mahmood observed that marriage according to Muslim law is not a sacrament but a civil contract. All rights and obligations it creates arise immediately and simultaneously and are not dependent upon any condition as to the payment of dower by the husband to the wife. The contract of marriage under Muslim law may be dissolved by the husband, by the wife, by mutual consent of both husband and wife, and by judicial decree of the court. In this lecture, we will be discussing the dissolution of Muslim marriage by the husband and the wife and divorce by mutual consent of both husband and wife. The last type of dissolution of marriage, that is dissolution by judicial decree of the court, we will be discussing in the second part of the lecture titled Dissolution of Muslim Marriage Part 2. In accordance with Muslim law, a marriage is terminated through the demise of either the husband or the wife, or through the process of divorce. Upon the demise of the wife, the husband is permitted to enter into a new marriage without delay. However, the widow is prohibited from entering into a new marriage until a specific period known as iddat has elapsed. The duration of iddat after death is 4 months and 10 days. If the woman is pregnant, the iddat period extends until the delivery of the child. Let's discuss the dissolution of marriage by husband according to talaq. First, we will discuss the meaning of talaq, which is divorce under Muslim law. Talaq in its original sense means repudiation or rejection under Muslim law. It means a release from the marriage tie. The talaq may be pronounced by express words or by elusive words. Talaq may be effected orally or by a written document called talaqnama. There is no special form of talaq recognized by the Sunni law. All that is necessary is that the words of talaq, as pronounced by the husband, should show an intention to dissolve the marriage. But under Shia law, there is a prescribed formula that must be recited orally in the presence of 2 competent witnesses in order to effect the talaq. So, in order to pronounce a valid talaq, the husband must possess the following qualifications under Shia law. So, every Muslim husband of sound mind who has attained the age of puberty is competent to pronounce talaq, provided talaq is not pronounced in any form of compulsion, duress, etc., and is pronounced orally and in the presence of at least 2 witnesses, unless the husband is unable to speak. Under Sunni law, a person of sound mind who has attained the majority may divorce his wife. Talaq pronounced under compulsion, intoxication or fraud is effective under Sunni law but void under Shia law. Under Sunni law, no witness is necessary at the time of pronouncing talaq. Under Shia law, witnesses are necessary for the validity of the talaq. Under Shia law, there must be at least 2 male witnesses who should hear the actual words. A divorce pronounced under mistaken belief is said to be a valid divorce. Similarly, a divorce pronounced under compulsion, jest, inadvertently, or by merely a slip of tongue is valid under Sunni law. Shia law is different on this point. According to Shia law, the most important element in divorce is intention. If there was no intention to effect a talaq, it would not be effective. A Muslim husband possesses the right to pronounce talaq either by word of mouth, that is orally, or in writing. So there is no specific format for effecting talaq. Under Shia law, a husband who is able to write may repudiate his marriage by way of writing, and he must also pronounce talaq in Arabic. A person who is dumb may give the repudiation in writing, but one who is able to speak is not allowed to do so. It is also necessary that the witnesses be present at the time of pronouncing talaq. The witnesses should be present at the time of repudiation. The witnesses should hear the words of talaq. In case of dumb person, witnesses should see the writing or the signs in which it is expressed. It is also necessary that the witnesses be present together. According to Sunni law, the talaq may be pronounced either in writing or orally. An ailing Muslim has been given the power to dissolve his marriage. This right is generally exercised by a man who does not want to give the right of inheritance to his wife after his death. When a man pronounces an irrevocable talaq in death illness and dies before the expiry of his wife's iddat, she is not entitled to take her share in his estate unless the talaq was given at her request. If the husband has died after the expiration of the iddat period, she will have no right to inheritance. So further, talaq may be effected by the husband in 4 ways: talaq ul sunnat, talaq ul biddat, ila or zihar. Talaq ul sunnat is also termed as talaqul sunnah, which means divorce in accordance with the requirements of the traditions. It is a traditional mode of divorce approved by Prophet Muhammad and is valid according to all schools and sub-schools of Muslim law. It is further subdivided into ihsan and hasan. Ihsan is the most approved form of talaq. This Arabic word ihsan means best. It is the most approved form of pronouncing the talaq. To be in ihsan form, the proceedings of divorce must satisfy certain conditions. So these conditions are as follows. Firstly, the husband must pronounce the formula for divorce in a single sentence. Secondly, the pronouncement of divorce must be in a state of purity, that is tuhar. A tuhar is a period when a woman is free from her menstrual course. Thirdly, he must abstain from intercourse for the period of iddat. When the marriage has not been consummated, a talaq in ihsan form may be pronounced even if the wife is in her menstruation. Where the spouses are away from each other for a long period or where the wife is beyond the age of menstruation, the condition of purity is not applicable, as decided in the case of Chand B versus Badesha, 1960. A pronouncement made in the ihsan form is revocable during iddat. Such revocation may be either expressed in words or implied. Cohabitation with the wife is an implied revocation of talaq. After the expiration of iddat, the divorce becomes irrevocable. Next is the hasan form of talaq. This is considered a good mode of talaq. In Arabic, hasan means good. As terms signify, a talaq pronounced in the hasan form is of a lesser worth than the one pronounced in the ihsan form. To be in hasan form, the proceedings must satisfy the following conditions. Firstly, there must be 3 successive pronouncements of the formula for divorce. Secondly, in the case of menstruating wife, the first pronouncement should be made during a period of tuhar, the second during the next tuhar, and the third during the succeeding tuhar. Thirdly, in the case of non-menstruating wife, the pronouncement should be made at successive intervals of 30 days. Fourthly, no sexual intercourse should take place during these 3 periods of time. So this divorce becomes irrevocable on the third pronouncement. The next form of talaq which we will discuss is talaq-ul-biddat. This is the disapproved form of talaq. It is an irregular mode of talaq introduced in order to escape the strictness of the law. In this kind of talaq, 3 pronouncements are made during a single tuhar in one sentence, clearly indicating an irrevocable intention to dissolve the marriage. It becomes irrevocable immediately. In the year 2019, an act named the Muslim Women Protection of Rights on Marriage Act was passed to protect the rights of married Muslim women and to prohibit divorce by pronouncing talaq by their husbands. Talaq means talaq-e-biddat or any other similar form of talaq having the effect of instantaneous and irrevocable divorce pronounced by the Muslim husband as defined under section 2 clause C of the Act. Under the Act, any pronouncement of talaq by a Muslim husband upon his wife by words, either spoken or written, in electronic form or in any other manner whatsoever, shall be void and illegal. Said offence held can only be committed by a Muslim husband. Mother of husband who pronounced triple talaq cannot therefore be made liable for the same, as decided in the case of Rehna Jalal versus State of Kerala, 2021. Under section 4 of the Act, any Muslim husband who pronounces talaq referred to in section 3 upon his wife shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. Moving further, the next form of dissolution of marriage by the husband is by illa, which means by oath. In Muslim law, illa, also known as vow of continence, refers to a situation in which mentally sound husband takes an oath before the God that he will abstain from engaging in sexual intercourse with his wife for a duration of 4 months or more. The marriage is permanently dissolved once 4 months have passed unless the husband restarts living together during that period. If the husband does resume cohabitation within 4 months, the illa form of divorce is nullified and the marriage remains intact. Moving further, the next form of dissolution of marriage by the husband is by zihar. If the husband, who is an adult, compares his wife to his mother or any other female within the prohibited degree of kindred, whether by consanguinity, affinity, or by fosterage, rendering marriage with them absolutely unlawful, the wife has right to refuse herself to him until he has performed penance. Zihar may be expiated by the fast for 2 months successively or by feeding 60 poor men. The wife is entitled to prevent her husband from enforcing conjugal rights until he has made proper atonement for her. In default of expiation, the wife has right to apply for judicial divorce. The Shia law insists on the presence of 2 witnesses when any injurious assimilation is made to the wife. Mutta marriage, which admits no other sort of divorce, may be dissolved by zihar. This form of divorce has become obsolete now. Next, we are going to discuss the dissolution of marriage at the instance of wife under the husband's delegated power, which is the talaq-e-tafweez. The doctrine of tafweez or delegation of power is an important topic of the Muslim law of divorce. The husband may either himself repudiate his wife or delegate this power of repudiating her to a third party or even to his wife. Such a delegation of power is called tafweez. An agreement made either before or after the marriage, providing that the wife would be at liberty to divorce herself from her husband under certain specified conditions, such as if the husband marries the second wife or fails to maintain her for a specified period, is valid, provided first that the option is not absolute and unconditional, and secondly that the conditions are reasonable and not opposed to public policy. The mere fact that the husband delegates to the wife the power of pronouncing her own talaq does not deprive the husband himself of his right to pronounce the talaq. In the case of Mirjan Ali versus Maimuna Bibi, 1949, it was held that the wife exercising her power under the agreement must establish that the conditions entitling her to exercise the power have been fulfilled. In such cases, the mere happening of the contingency is not sufficient. The wife must clearly establish first that events entitling her to exercise adoption have occurred, and secondly, that she actually exercised her option. Next, we are going to discuss the dissolution of marriage through lien at the instance of the wife. Lien is a form of divorce that a Muslim wife may seek if her husband accuses her of adultery and the accusation is proven to be false. In such cases, she has a right to initiate legal proceedings to obtain a divorce. In order to dissolve a marriage, she must initiate a formal lawsuit rather than simply applying to the court as the latter is not considered a suitable approach. The features of lien are as follows. A husband who is an adult charges his wife, who is also an adult, of adultery or denies the paternity of the child. If the charges prove to be true, a decree for the dissolution of marriage would not be granted in favor of the wife. Such a false charge does not ipso facto dissolve the marriage. It only gives the wife the opportunity to move to the court to dissolve the marriage. The marriage continues until the decree is passed. She must file a regular suit for the dissolution of marriage. A mere application is not enough. The Muslim law permits the man to retract the charge on 3 conditions. First, the husband must admit that he has made the charge of adultery against the wife. Second, he must admit that the charge was false. And third, he must make the retraction before the end of the trial. So next we are going to discuss the dissolution of marriage by mutual consent by both husband and wife, namely khulla and mubarat. Khulla or redemption means to lay down. In law, it means the husband laying down his rights and authority over his wife. It is an agreement entered into for the purpose of dissolving a marriage tie in lieu of compensation paid by the wife to her husband out of her property. A divorce by khulla is a divorce with the consent and at the instance of the wife, in which she agrees to give consideration to the husband for her release from the marriage tie. In the case of Bilqis Ikram versus Najma Ikram, decided in the year 1931, the court held that under Muslim law, the wife is entitled to khulla as a right if she satisfies the consignments of the court that it would otherwise mean forcing her into a hateful union. The essentials of khulla are as follows. First, there must be an offer from the wife. Second, the offer must be accepted with consideration for the release. And third, the offer must be accepted by the husband. There are certain cases in which wife agrees to pay something or give something in consideration for her release, but after being divorced by her husband, fails to fulfill her promise. In such a case, the divorce does not become invalid and the husband has right to claim the consideration, because as soon as an offer for khulla is accepted, it becomes an irrevocable divorce and the wife is bound to observe iddat. Under the Shia law, the conditions necessary for effectuation of a valid talaq through khulla are that the husband must be an adult, of sound mind, a free agent and have the intention to divorce her. Under the Sunni law, only 2 requisites are essential. The husband must be an adult and of sound mind. Next we will discuss mubarat. Mubarat is also a form of dissolution of a marriage contract. It signifies a mutual discharge from the marriage claims. In mubarat, the version is mutual and both sides desire separation. Thus, it involves an element of mutual consent, as decided in the case of Jani versus Muhammad Khan, 1970. In this mode of divorce, the offer may be either from the side of the wife or from the side of the husband. When an offer is accepted, it becomes an irrevocable divorce and iddat is necessary. The difference between khulla and mubarat is as follows. First, khulla is a redemption of the contract of marriage, while mubarat is a mutual release from the marriage tie. Second, in khulla, the offer is made by the wife and its acceptance is made by the husband. In mubarat, any of the two may make an offer and the other accepts it. Third, in khulla, consideration passes from the wife to the husband. In mubarat, the question of consideration does not arise. Fourth, in Khula, the aversion is on the side of the wife, while in Mubarat, there is a mutual aversion. Both Khula and Mubarat are to be followed by the observance of Iddat. Mubarat operates as a single, irrevocable divorce. The marital relationship cannot be resumed by mere reconciliation, and formal marriage for such resumption is absolutely necessary. We can conclude by saying that a Muslim marriage is a contract that can come to an end at the instance of the husband, wife, or by mutual consent. With this, we come to the end of the lecture.